because there is only one non-antitrust matter left, and it's a summary matter. Sarah, would you give us the 2 minutes on what you need from us on the state and local agency access proposal?
Probably do it in less. Good afternoon, commissioners. I'm presenting memorandum 2024-27 related to the notice of administrative subpoena. This memo presents an update and proposed next steps. Staff met with representatives from Assemblymember Kalra's office and the California Department of Justice in early June to discuss DOJ's concerns with AB 522. And given the significance of DOJ's proposed amendments and the late stage of the legislative process, Assemblymember Kalra chose to hold the bill in Senate Appropriations Committee. And this will give us more time to fully survey the affected agencies and get broader input. Would the commissioners like the staff to begin stakeholder outreach to discuss potential revisions to the commission's recommendation?
Now, do you need a motion from us to move this back out for public comment?
I don't believe we're at the public comment. Public comment generally?
Outreach. Right?
Well, the outreach, do you need anything from us to take it to your next step?
I don't believe so.
Okay. Is there any commissioner who has a question on this agenda item? Hearing none. Thank you.
Thank you.
Now we'll turn back to antitrust. I want to make sure that our formal proceedings do not squeeze out public comment. So if there is a way to identify how many people on the Zoom, Kristen, are interested in commenting, we'll proceed with the agenda, but with the knowledge of who's waiting. I think that would be useful.
Yes, so for people who are on the Zoom and are interested in public commenting, please raise your hand. And so we will keep track of the number of hands that get raised. But please raise your hand now and just know that we'll be taking up public comment later. Thank you.
Thank you. Okay, back over to you. We have a hard stop, no later than 5.
Yeah.
Flights. So that leaves these 3 items.
Yes. All right. We're back to the antitrust agenda. At this time, we have a group of 4 individuals or organizations who are going to present comments on the expert reports that were just presented. As Kristen hopefully knows, 3 of them are by Zoom, so hopefully they are logged in and raise their hands when they're up. So I think we can start, since he's in the room, we can start with Aaron Benjamin first, if you would introduce yourself. And I just want to remind everybody we're on strict timelines, so you have a total of 10 minutes per organization to present, and that allows time for commissioner questions as well, and if we need to ask our experts any questions as well. Thank you.
Members of the commission, thank you for this opportunity. My name is Aaron Benjamin. At Google, I lead competition policy for the US and the Americas. It's great to be back here in California. For 5 years, I was fortunate to call California home. And though I no longer live here, what has stayed with me is the spirit of innovation, which has made this state's economy the envy of the country and the world. Google embodies this spirit, starting in a California garage with a big dream to organize the world's information and make it universally accessible and useful. At first, our search results were just 10 blue links on a page. 25 years later, we provide richer results with direct answers to questions, pinpoints on a map, links to flights and products, and now AI-generated responses. Our work is not done. New information is constantly being created in a range of formats. People's expectations continue to evolve, from searching with text, to searching what you see with your camera, to asking a question with your voice. California has benefited from our innovations. We've proudly called California home since our founding, with our global headquarters in Mountain View and 11 other offices across the state, and now over 52,000 employees here in California. Last year, we helped provide $166 billion of economic activity for hundreds of thousands of California businesses, nonprofits, publishers, creators, and developers. Last year, more than 2 million California businesses used our free tools to receive phone calls, bookings, reviews, requests for directions, or other direct connections to their customers. And we've invested over $4 billion in California startups. Google's not alone. California tech firms like Adobe, Apple, Broadcom, Cisco, Dolby, eBay, Meta, Intel, Intuit, Netflix, OpenAI, Oracle, PayPal, and Qualcomm have spurred successive waves of technological transformation, from semiconductors to networking to Web 1.0 to mobile, cloud, and now artificial intelligence. In today's age of AI, the list of California firms is longer, more crowded, and more dynamic than ever. As Governor Newsom noted earlier this month, California is now home to 35 of the world's 50 leading AI companies. As the AI revolution disrupts existing technologies and business models with more choice, more competition, and more innovation for consumers in the wider economy. Competition is why Google spent over $45 billion on research and development last year, more than NASA, up 15% from the year before. New competitors in the AI arena aren't just digital giants. There are thousands of new startups investing and growing in this area. OpenAI is one of them. It launched ChatGPT in November 2022 and surpassed 100 million users a month later. The high fixed startup costs for previous generations of technologies, like large server farms, are now lower variable costs for new players. They can rent cloud computing services from a range of providers and scale their operations as they grow. It has never been easier to build a successful technology business with novel, differentiated ideas. Technology changes, but California remains at the center of the new developments and enormous changes underway due to AI. At this crucial moment for the tech sector, it's important that this commission ensure California remains an environment that fosters innovation, benefiting consumers and the wider economy. Essential to California's success has been its long-standing pro-consumer and economy-wide antitrust framework that protects consumers rather than producers. These policies are designed to ensure that firms of any size and in any industry continually innovate to increase choice and quality for consumers. Current California and federal antitrust laws prohibit a range of anti-competitive practices, while not inadvertently banning pro-competitive, pro-consumer practices that lead to better products, more choices, and lower prices. These laws have enabled a century of technological progress while curbing practices that reduce innovation and harm consumers. And today's tech companies are not beyond reach. Google and others have been subject to antitrust litigation under existing state and federal laws from both government enforcers and private plaintiffs. This litigation is playing out through court cases that will establish the appropriate balance between vertical integration and horizontal openness in a range of contexts. In contrast, Europe's unique ex ante regulatory approach, which imposes rigid product design rules that tell a company what products it may and may not design without considering the benefit or harm of those products, creates trade-offs for a range of small independent businesses and consumers. Without safeguards for pro-consumer innovations, these rules can restrict useful product designs, which inevitably have knock-on effects on a range of small independent businesses. We've removed useful Google search features for flights, hotels, and local businesses as part of changes designed to address complaints from intermediaries under the EU's Digital Markets Act. This means that if you search for a flight in Europe, we no longer show a full array of information about carriers, flight times, and prices. This benefits a small number of online travel intermediaries who have long complained about competition from Google services that benefit consumers. But these changes have come at a cost, making it harder for European consumers to find useful information and reducing direct traffic to a wide range of airlines, hotel operators, and small businesses who now find it harder to reach customers directly. We introduced these Google search features to help consumers, making it easier for people to access accurate and reliable information. But to address complaints from intermediaries in the EU, there's now more friction when you search on Google in Europe. And there's a greater risk that you'll end up on a travel website advertising a low fare that jumps just before you make a purchase with a message like, "This fare is no longer available." As a result, Europeans are raising concerns on message boards and in our help forums that they no longer see useful features on our search results page. And it's not just consumers. Suppliers are complaining too. Hotels are concerned that direct booking clicks are down as much as 30% since our compliance changes were implemented. These businesses now have to connect with customers through a handful of intermediaries that typically charge large commissions, while traffic from Google was free. European airlines and local businesses have expressed similar concerns. We've always been focused on improving Google search to help you quickly and easily find what you're looking for. We developed Google Images to show a photo instead of just a link to a photo. We launched Google Maps to help you find a local business, not just a website that mentions its address. And we developed ways to make it easy for you to directly connect with airlines, hotels, and merchants, saving you time and money. These features also help a lot of independent businesses, including small businesses, compete with large, influential websites. Rules that roll back some of these advances would represent a fundamental shift in California's antitrust policies. We encourage this commission to consider the potential adverse consequences, including those for consumers and small businesses who tend to have less voice in the regulatory process. In our view, the best approach is to ensure consumers can continue to choose the services they want to use, rather than requiring companies to redesign products to benefit a handful of commercial rivals at the expense of consumers and merchants. An environment that encourages firms to innovate and create the best products for consumers will help California continue to attract the next wave of technology progress. Thank you for your time today. We look forward to continued engagement with the Commission throughout this process.
Just to be clear, you're fundamentally suggesting that we not move in the direction of importing the EU sort of structure for evaluating businesses, monopoly and mergers and all that sort of stuff, right?
Shifting competition policy away from protecting consumers and toward protecting producers comes with serious long-term risks. I mean, think of a smartphone. A smartphone is a product combination of a dozen different products, a calculator, a camera, a GPS device. If we had a competition policy 20 years ago that was focused on protecting producers, we'd still have calculators. But the consumers in the wider economy.
I've still got my slide rule at home, so yeah, I get you. Okay. Thank you.
Yeah, so I will start promoting to panelists. I see that there are, I believe, 3 participants from Yelp, so I will be promoting each of those individuals to panelists as I can find them. So that will just take me a moment. Oh, I think I misclicked that one. Okay. I believe, let's see. There,
Thank you for your patience as we work out our technological challenges.
they are all showing as panelists now. I think not everyone has their camera on. So
Are we ready? David,
yes.
are you there?
Can you hear me?
Yes, yes, we can hear you. And I believe you have slides. It would be fine for you to run them. And
Okay,
if you
let
have
me-
other individuals will you please have them represent or introduce themselves? And our understanding is you're all representing Yelp.
That is true. And I'm David Siegel, VP for Public Policy, here with Peter and James, if they want to say hi quickly.
Hi, Peter Curzon, Vice President of Business Development for Yelp.
Hi, James Dare, Associate Director of Legal at Yelp.
Okay, and let me get these running. I had sent over a copy of the slides late last night.
If I
but-
can pause you for just a minute, I'm sorry. Kristen, it's a little hard to hear. Can you make it louder? We'll let you know when it's a little louder. Are we ready?
Yes, so I think we're ready. That's the max volume I can get on that there, so.
We'll make do whatever it is now.
Okay, and I need one moment. I had sent over a copy of these slides last night. Let me just call them up here. I think I've got them somewhere. Sorry, this will take another moment or two.
We do have the slides available if you want us to run them remotely.
Okay, actually, I think I've got them here now. Actually, it'd be easier if you'd be able to do it, that'd be great.
It'll take just a moment, but we will get that set up.
Thank you. Awesome. So thank you for having us. There's a table of contents, and I think we can click forward a couple of slides before we get to the substantive part. And I'll read through these. If it's okay for me to say so, we will have some material that's directly responsive to some of Google's assertions later in the program. Towards the end of this presentation, Peter is going to present our what we call the focus on the user proposal that demonstrates how Google could, in fact, despite its assertions, offer a seamless user experience that complies with a ban on self-preferencing. But I just wanted to name that at the top since it's directly responsive to some of their comments from a moment ago. But quickly about Yelp. So Yelp is a California-based, internationally recognized brand and corporation whose principal aim is to connect consumers with great local businesses. More than 80 million people visit Yelp's platforms each month, and Yelp's users have written nearly 300 million reviews of businesses. Despite this success and despite Yelp's ongoing commitment to innovation and investment in its core business lines, we continue to face barriers to expansion in an industry that's increasingly dominated by big tech. Big tech has transcended the innovative prowess that defined its initial growth phase and is now reaping the rewards of its dominance by inhibiting market entry and innovation by rivals. It's thus not surprising that it has come into the crosshairs of federal and state antitrust enforcement authorities increasingly over recent years. And Yelp has commented extensively on the lawsuit brought by the DOJ and dozens of states against Google's search monopoly and has publicly advocated for rigorous remedies if the court finds Google liable in that matter. Next slide, please. Yelp is generally supportive of legislation to rein in the abuses of dominant tech companies, including through prohibitions on exclusive dealing by dominant firms, on self-preferencing, tying or bundling of separate business lines, more rigorous scrutiny of mergers and acquisitions by dominant tech firms, which have been at the core of big tech strategy to quash potential rivals and reinforce dominance across entire ecosystems, various technical and gap-filling measures to address innovative attempts by big tech to evade federal antitrust scrutiny. We think the future of tech innovation in California depends on a fair marketplace that encourages innovation by small and mid-sized firms. Consumers, working people, and entrepreneurs all stand to benefit from enhanced antitrust enforcement, along with clear, bright line rules that improve front-end compliance with fair and equitable market standards. Next slide, please. And the next one. And I don't need to go into detail here, but we can, I guess, roll through the next couple, but this just goes at some of the slew of cases brought by the federal government, state governments, and by private businesses against big tech. The next slide would be great, please. You can see that between this and the slide that follows, that all of GAFA is in the crosshairs of antitrust enforcers now. That first case, the search case, is the one I referenced previously, which was at trial starting last fall and saw closing arguments a month or so ago. Next slide, please. California on its own has initiated litigation relative to Amazon. And we see two pending cases around app stores by Epic against Google and Apple. And the next slide, please. So our first recommendation is to adopt an abuse of dominance standard. So as has been noted over the course of the day, current antitrust law at the state level as at the federal level is not always adequate for challenging the actions of big tech corporations. Because enforcers and judges have focused on what's known as the consumer welfare standard, antitrust cases hinge on consumer prices and so-called efficiency within businesses, rather than antitrust law's traditional role of protecting businesses and workers from abusive or anti-competitive tactics by powerful firms. Several states are considering legislation that would create an abuse of dominance standard for state antitrust laws. And such a standard would supplant the current consumer welfare standard, which requires stricter proof of monopolization and allows for various so-called efficiency defenses to otherwise anti-competitive conduct and market structure. Next slide, please. And the next one. And this is where we'll go into more detail in a few minutes, and also speaks to some of the issues that were raised relative to the DMA by the previous presenter. We support a prohibition on self-preferencing by the big tech platforms. Google's self-preferencing practices. Sorry, was there one slide before this? I'm sorry, this might be there. Thank you. So many big tech corporations both run platforms and provide content for those platforms using their own products, giving them a large incentive to self-preference, even when better products or content is available elsewhere. For instance, Google gives Google Maps and its local search product more prominent placement in search results, even if another service has better information for that location or more and better choices for consumers. And studies have repeatedly shown that users prefer the so-called organic search results, those that flow from a consistent and objective algorithm, to those produced by Google's search engine when it engages in such self-preferencing. FTC economist Devesh Raval conducted another study showing that gatekeepers like Google and Facebook provide less trustworthy content to consumers with artificially inflated reviews for lower quality businesses, and that services like Yelp actually provide more accurate and better trusted information. And the next slide, please. So Google's self-preferencing practices are especially problematic in the current era of artificial intelligence development. Google seeks to leverage its search dominance to achieve dominance in the AI space, integrating its flawed large language model with its search platform and serving a litany of results that range from the ridiculous to the potentially dangerous. For instance, encouraging users to eat rocks or to add glue to pizza recipes. And at the end of this presentation, as I've referenced, Peter will give a presentation on our focus on the user proposal that explains how Google could offer users a seamless local search experience while also ending self-preferencing. The next slide, please. And the next one, please. Recommendation 3 is to prevent various tactics to evade scrutiny by enforcers and regulators. So as federal and state enforcers have more aggressively challenged corporate concentration, dominant firms have developed a variety of tactics to avoid scrutiny, sometimes walking right up to a clear line defined by existing law or jurisprudence. These tactics are particularly prevalent, again, in the AI space. They include securing voting members and/or observers on boards of firms they seek to control, taking ownership stakes just below majority thresholds, serial roll-ups of smaller firms below existing reporting thresholds, and buying up essentially all of a firm's employees, but not its corporate structure. And while many of these tactics will likely be challenged, delays in enforcement of competition laws frequently mean that anti-competitive behaviors can run their course and potential rivals lose their abilities to compete and thus go out of business. Enforcement would be swifter if there were clear statutory prohibitions on regulation of such behavior. And one more, please. And our fourth recommendation would be structural separations of platform utilities from downstream licensors. So tech firms are now more vertically integrated than ever before. When firms become integrated across numerous tiers and business lines across the supply chain, they compete directly with downstream firms that depend on them for access to users. For instance, Google has exploited its vertical integration across its Android operating system, its search engine, and its ad exchange to prevent entry by rival firms. Google's integration of Android, the Google Play Store, and in-app payment systems has driven up costs for developers and consumers while preventing rivals from providing higher quality products and lower cost payment options. Vertical integration across business lines can result in irreconcilable conflicts of interest. And as a U.S. House Judiciary Subcommittee investigation on competition in digital markets recommended, lawmakers adopt legislation to structurally separate business lines and compel dominant firms from engaging in vertically integrated lines of business that encourage these conflicts of interest. We recommend the Commission adopt a similar approach to enhancing competition and innovation in California's tech industry. And the next slide, please. And I'll hand it over to Peter to explain our proposal.
Okay, so putting it into practice, Yelp recommends that Google ends self-preferencing. And so instead, we recommend that it displays the best and most useful content to consumers. And so to do that, we recommend that third parties supply their content directly to Google. So Google will ingest it and then rank these different pieces of content and then use its strength in ranking algorithms to determine which one is the most useful to consumers. They're already doing this in organic search. And so they could do this in some of their features that are currently self-preferencing Google content today. And so instead, Google would take that most useful content and display it to consumers and include links to those third-party platforms for consumers who do want to learn more information. And so looking at what this looks like on the next slide, we've mocked up an example. And so here a consumer did a query for a local business. And the first search result that Google renders is for the business's website, which makes a lot of sense. And then after that, there are third-party services that Google has determined, in this particular case, OpenTable is the most useful information to consumers in that next slot. And so we're proposing that in some of the embedded features that Google has built into search, such as this feature on the right-hand side of the screen that's called the Knowledge Panel, that this information be supplemented not with Google's proprietary information that it's collected through embedding its own products into search, but using the most helpful third-party content, again, as determined by Google through its organic search rankings, and including that content in these features and then linking off to that third party instead of always including Google content, even if Google has less information or less reliable information than some of the companies that would show up in the organic search results. So going on to the next slide, you can see another example of this where a consumer maybe hasn't made up their mind yet. They're doing a category query, looking for something like restaurants nearby. And so Google has a feature called the One Box, where Google actually recommends here are a few different options for you, which is helpful for consumers. But when Google self-preferences its own content above any other content on the internet, we believe that the self-preferencing should stop and Google should use whatever best content it has available, which could include from third parties. And so here, if we go on the next slide, you can see a zoomed in version of the mock where you can see on this first result, we've mocked up Yelp being the provider of that information, and then OpenTable in the second result and TripAdvisor in the third. And again, consumers could click on to learn more from any of these pages. And in each of these instances, Google can continue to do what it does very, very well, which is rank content and evaluate reliability. But then Google should be promoting that content that is the most reliable and trustworthy and not defaulting to just serving its own content that it has in-house. So the next slide, just showing how we're recommending that clicking on any of this content would link out. So not only are consumers getting the most useful information in this sort of flow, instead of always being routed into Google properties, such as Google Maps, but in addition, it creates more competition and distributes more of this traffic across the internet, as opposed to keeping it all within the Google ecosystem. And I believe that is, yeah, the last slide. So here, just summarizing, we recommend Google stop self-preferencing its own content. It should display the best content to help consumers. To do that, third parties can supply their content to Google. Google could evaluate which content is the most useful, which it already does in its organic ranking algorithms. And then Google should display the most useful content to consumers and then send those consumers to those sites. Which would also increase, not only help consumers get the best information, but distribute that traffic across the internet, enhancing competition. Thank you.
Are there any questions from commissioners or staff?
I do have a question, actually. I know
Please
there
do.
was a reference in the slides about the best and most useful content, right? So I believe there was some indication that there would be a third-party entity that would determine that. I want to hear a little bit more about how that will be determined. What is the best and most useful content?
Sure, I'm happy to answer that, and I'll begin answering, but if the slide number 21 in our presentation could be put up in parallel, that'd be really great. So Google today, when you do a query for a given local business or anything for that matter, Google's ranking algorithms have already indexed content across the internet, and then they have determined that of 10,000 or some large number of results, that result number A or B or C in this particular case, when consumer queries for lobbies in Washington, D.C., that the most helpful piece of information, the first result is the business's website, the next one's OpenTable, the next one's Michelin Guide after that. So what we're recommending is Google use this ranking algorithm that it already has and already determines which content is most reliable. This is a ranking algorithm that I think somewhat famously is called PageRank, or used to be, that takes in a bunch of different signals that indicate trust and helpfulness. And so we're recommending that Google looks to its own ranking algorithm to consider more candidates for who could serve content in these features. Whereas in contrast, today, Google does not look through its organic search results or have a ranking concept for where the most useful information is. It unilaterally and solely serves Google's proprietary information in these features, this knowledge panel and one box information. So it's just the Google reviews and local business information independent of quality, which is what Google's ranking algorithm already does today in trying to determine what is the most useful content to promote to consumers.
Commissioner Simpson?
Again, some of the terminology is a little new to me. So I'm still not clear on the difference. Is it rather than, I guess Google has some method of identifying quality responses to the search, and you're suggesting an alternative way of ranking responses to the search?
So recommending an alternative way to, well, let me answer it slightly differently. So right now, the way that Google works is there are organic results or results that Google thinks are the best answer, but then there are also features that promote Google content above what Google thinks is the best answer. And so actually, I think
when you say Google content, what do you mean?
Yeah, maybe if we go to the next slide. So these are mock-ups that have modified what Google looks like today. So Google looks very similar to this, with the exception of where those little red arrows indicate third parties providing those contents, like the rating and review counts. Today in Google search, those would all be ratings and reviews and content from Google. And so if I type in that query for French restaurants, and then I tap on any of these features, I'm taken into Google Maps. And so I never leave the Google ecosystem. And so even if, let's say that, let's take a category that we all care about. Actually, we can use dentists. So when I moved to San Francisco, 13 years ago, the first time I found a local business on Yelp was to find a dentist. And so if Google has 2 reviews and they're actually written, and I'm just saying this is a hypothetical, but if they're written by, employees from that business, or, they're, it's like 1 star, the business was bad. That's not very helpful to a consumer. Whereas if you contrast that with content from one of these other sites that could have 100 reviews and trust signals that, or methods of eliminating low quality content. And so without going too far, rabbit holing here, Google puts its own content into this box, no matter whether it has much reliable content or not. And I'm proposing, or we are proposing, that these features that are promoted at the top of the page above the fold that receive more clicks than content buried further down the page, we think that these features should be opened up and not just show Google content that directs into Google owned properties or assets, so that Google sort of has its thumb on the scale and can grow its own properties and not either send users to more helpful places or promote more competition.
Okay.
So I just did
And
a
I would,
search.
and sorry, yeah, I would encourage you to do your own search on your own device. You can test all
Right.
this as you go.
Yeah, that's what I did. So I looked up French restaurants, Washington, DC. The first thing I see is places. It has the map and a listing of the restaurant. I can click on a tab that says more places. Is your issue the fact that it's a Google map?
It's
Or
that
what?
all this content, yes, is coming from Google, and that, again, independent of quality, Google is driving more of this traffic into its own properties, which then it's also serving ads against and monetizing. But consumers are not receiving, in many of these cases, we believe, the most useful information.
Okay.
And
So what you're saying is those that appear on this Google map are those that have paid to advertise on the Google platform.
no, if you were to do a query for a plumber, for example, this feature is not a paid feature. Right here, this one box, but you will see paid ads above the one box in one of these commercial categories where Google serves many ads and monetizes. Yeah.
Thank you all. We don't intend to start a tennis match, but Mr. Benjamin, if you have any comments to make, now would be the time to make them, and then we'll move to the next segment.
When we started Google, there were lots of other search engines. Google came along with a new method, a way of ranking websites that people found more useful. But over time, we learned that people's habits were changing and they wanted different types of information. Say I typed in California EPA. Maybe I'm interested in the composition of the agency, or maybe I want to know where it's located and how to get there. I want to see a map, hours of operation. And so we innovated and made Google more rich and to provide these types of information. And others have complained about those innovations, complained to the FTC. And the FTC found that these are product improvements that enhance the experience for consumers. Don't want to be routed to another website. As Commissioner Kubas mentioned, they want to go to a restaurant. They don't want to go to another website that will show them the restaurant. They want to go directly. And so there are those who say that there should be lanes and turf, and Google, you don't do reviews, only we get to do them. But subdividing the economy into lanes means that there's less competition, not more, leaving consumers with fewer choices and less innovation.
Thank you. Mr. Siegel, last 30 seconds, and then we'll move on.
Thanks, Travis. I would just say we are not saying Google should not be able to do reviews. We're saying that everybody should be able to compete on a level playing field, and Google should not actively subvert its underlying algorithm by placing only Google content above its organic results, such that fewer and fewer people see the organic results that include Yelp, include TripAdvisor, and other rivals in this particular space. And this behavior replicates across all sorts of other verticals in which Google is operating these days. And we'll follow up with a more in-depth comment and really appreciate the opportunity to speak before you today. Thank you very much.
Thank you all. We appreciate your input.
So next up on the agenda, we actually have two professors. The first one on our list is Professor Barnett. Kristen, is he ready to go? Thank you for presenting, Professor Barnett. And just as a reminder, you have a total of 10 minutes. Thank you.
All right. Well, thank you. And thank you very much to the members of the commission for the opportunity to present my research, my report to you. Just the standard disclaimer to start off with, the views I express are solely my own and should not be attributed to any other institution or entity. The question I addressed in this report is whether it would be advisable from a public policy perspective, and specifically from California's interests in maintaining a competitive innovation economy, would it be a good idea for California to adopt some or all elements of the Digital Markets Act that has been enacted in the European Union and has been implemented since approximately May of 2023. And my conclusion in the report, as you know, is very simple, that it would be inadvisable, it would likely be against the best interests of California's innovation economy, and ultimately the California consumer to adopt the approach reflected in the Digital Markets Act. And what I'm going to endeavor to do in the next 10 minutes is to condense an almost 60-page report into 5 big reasons why I reach that conclusion. The first reason is really a big picture data point. The California innovation ecosystem is universally recognized as the highest performing innovation ecosystem in the world. There is no peer to it. And therefore, following the principle that if something is not broken, we should be really careful about changing any part of the existing institutional infrastructure, we might want to act with extra caution. And related to that, part of this first reason is that if we look at the largest, most successful, as measured by revenues, technology firms in the world, most of them are located in the United States. The largest portion of the US-based firms are based in California. All of the remaining, if you take the top 15 firms every year since 2018 by revenue, most of them are US firms. The largest portion are California-based. The remainder are in Asia. You will not find one firm in the European Union that falls into that category. Just to give you some context, the current federal antitrust case law and the approach reflected in that, which I'll be describing to you, has been in place for almost half a century. The reason I want to emphasize that point is while there are lots of other factors that explain California's success, the antitrust legal infrastructure that I'm going to describe to you has been in place for almost half a century, and the innovation economy in California has exploded and outperformed every other innovation economy during that time. By contrast, Europe, which of course has only recently operated under the DMA, but the DMA, as I'll explain, reflects certain elements of European competition law that have been in place throughout this period. Its innovation economy during this time has declined. Outside of pharmaceuticals and certain portions of the wireless sector, the European Union is a minor player in the global innovation economy. It therefore would seem that we should act with some caution in importing elements of the regulatory structure that they have been using during that time. The second point I would like to make is that California-based tech firms already operate today under multiple layers of antitrust scrutiny. And from a certain perspective, it could arguably be said an even stricter level of enforcement than exists in the European Union. Let me explain to you why I make that point. The California innovation economy is, of course, subject to the federal antitrust laws. Unlike in Europe, though, it is enforced not just by the federal enforcers, it's enforced by 51 state attorneys general. On top of that, only the US has an active class action bar that also has private rights of action under those antitrust laws, and they use them actively. There is no comparable equivalent in the European Union. That's not all. California firms are subject to the Cartwright Act. And while California courts' case law generally mimics the case law of the federal courts under the Sherman Act in order to provide relatively uniform treatment, the California courts, the California Supreme Court, has been clear that the Cartwright Act does afford California state courts latitude to find liability where a practice violates the spirit of the antitrust laws, even though it might not violate the letter. And just to finish up the point, the Federal Trade Commission under Section 5 of the FTC Act has similar such latitude. I want to emphasize this point because it's sometimes argued today that the existing antitrust structure in the US is lax, especially as compared to Europe. For the reasons I've mentioned, I don't think that is at all clearly the case. In fact, it could be argued that the level of enforcement, when you take into account how many actors can bring causes of action, may be even stricter. The third point I would like to make is to draw an important distinction between the antitrust tradition in the US, which is a common law, litigation-based tradition, founded on the application of the rule of reason. The DMA reflects a different approach. It's a regulatory approach. It sets rigid, per se, illegal categories of activity. It operates ex ante. The rule of reason outside the clearest cases of collusion, which I don't believe is your focus, has been a feature of US antitrust law well before the so-called Chicago Revolution starting in the 80s. In fact, one of the originators, the pioneers of the rule of reason, is Justice Brandeis. Many who argue today for a Brandeisian approach to antitrust argue that we should revert to greater use of per se rules. But Justice Brandeis, in the famous case of US v. Chicago Board of Trade in 1917, argued just the opposite. He argued for the rule of reason. Why did he argue for the rule of reason? because he argued for the rule of reason is necessary to give courts a full picture of the pro-competitive and the anti-competitive benefits of a particular practice. And one thing I would like to emphasize is that in the ensuing decades since that Chicago Board of Trade decision, the Supreme Court has made clear, especially in a case known as California Dental Association, that the rule of reason comes in many varieties, and courts should feel free to apply it more strictly, less strictly, greater or lesser fact-finding, depending on the complexity of the case. The rule of reason is far better founded in the economic literature than the per se rule, and that's because the economic literature almost universally recognizes that outside the clearest cases of collusion, which are always anti-competitive, that antitrust is hard, that many of the practices challenged in antitrust cases have good and bad effects on competition. This more careful approach, this litigation-focused approach, has allowed for a balance that on the one hand gives enforcers tools to protect consumers when anti-competitive practices are being used. But at the same time, it provides guardrails. It holds back the prosecutor's hand so that a chilling effect is not caused that can discourage innovation.
Professor Barnett, sorry
Yeah.
to interrupt you. You're at 10 minutes, so we're going to have to ask you to wrap up so we can keep on schedule. And we do appreciate your comments.
Absolutely. I was just about done. The last point I wanted to bring up, I won't get to 5, but I kind of merged it into 3. So I'll make this my last one. The last point I wanted to bring to your attention is that one of the arguments that are sometimes made for the DMA is that it will lower costs because instead of having litigations that go on for years, which can be the case, instead we have clean regulations that are easy to administer. If you've read the DMA, which is a complex statute, you might be skeptical of that, and your skepticism would be confirmed in the short period in which it has already been in operation. It has triggered disputes with regulators. It has triggered litigation over the interpretation of regulations. It is entirely possible that adoption of the DMA is more expensive than litigation-focused enforcement, since litigation occurs periodically, whereas the DMA would require California to set up almost an entire new regulatory entity to interpret, administer, and enforce the regulations. Thank you, and thank you for the extra few minutes to finish it up. I appreciate it.
And next up, we have Professor Newman. I think he's ready to go, Kristen. He will be appearing via Zoom. And Professor Newman, I'm going to remind you, like we have it with everybody else, that you have a total of 10 minutes so we can make sure we get to hear from everyone. Thank you.
All right, well, thank you for the reminder. And I'm mindful of the chairperson's warning not to be too professorial. And I'm also mindful of the fact that it's just after lunch out there, which is the worst time to have any class. So I'll try to keep things tight. I spent some time thinking about what unique insights I might be able to share with you all today. And to the extent I have anything, I think it's drawing from my most recent experience in practice. So I'm a professor at the University of Miami School of Law these days, but up until late last year, and for a couple years before that, I was serving as the deputy director of the Federal Trade Commission's Bureau of Competition at the invitation of Chair Lina Khan. And in that role, my portfolio was basically the FTC's big tech antitrust cases. So I was overseeing cases against Meta, 2 cases against Meta, a case against Amazon, and a case against Microsoft. And frankly, we had mixed results from those cases. A couple are still ongoing, but we got a couple of unfavorable judicial rulings. And so to the extent I have anything unique to share with y'all, I think it may be that I have as much or more firsthand experience with what makes it really, really hard to bring any kind of federal antitrust case against these big tech companies today. So I'm just going to start running through the list. It's a long one. Unfavorable precedent. The federal judiciary has developed some really unfavorable rules, some subtle, some blunt. That rule of reason that Professor Barnett was extolling a moment ago, and that is kind of the default that applies now in these cases brought under the federal laws. Sherman Act Section 1, which is the bedrock federal antitrust statute, in rule of reason cases that get litigated under that statute, defendants win, according to the last rigorous empirical study, more than 99.5% of the time. So what we basically have in the federal judiciary is these federal statutes that candidly are kind of a paper tiger. We still have cases, we still litigate them. Defendants win 99.5% of the time. That's quite a skew. You've got excessive deference, I think, to defendants' arguments. When you really look hard at these arguments, the economics don't hold up, or the facts don't hold up, or both. But federal judges are just way too willing to accept them at face value. That's kind of point number one. Point number two, increasing technical difficulty and complexity. We heard about that earlier from, I think, Professors Quokka and Krishnamurthy. This is partly due to a focus on quantitative evidence. It's also due to each individual plaintiff being incentivized to try a belt and suspenders approach, right? Each individual plaintiff wants to scattershot, try everything. And that then becomes the norm. And then going forward, next case comes along, the court's going to ask, well, why aren't you doing this empirical test that plaintiff did in the case before? It becomes the norm. Things become more and more and more complex. And then for private enforcers, they're facing explosion of mandatory arbitration clauses in contracts. There are ever increasing hurdles to class certification, and so on. Okay, so those are just general hurdles that you face in any case these days brought under the federal antitrust laws. What about big tech specifically? All right, first, big tech companies these days are not serving up the obvious meatballs, the slow fastball right down the middle of the plate, the Facebook, Instagram, obvious direct head-to-head competition going on. Zuckerberg, as we heard, is internally saying, yeah, let's buy them because they're about to eat our lunch competitively. Real problems. Google Waze is another example, just obvious direct head-to-head horizontal competition. Those deals got waved through. The big tech companies are aware that there are cops on the beat now, and they aren't serving up these kind of obvious meatballs anymore. The deals they're proposing are now kind of non-horizontal. Think of Meta buying Within Unlimited, a VR app studio. There wasn't direct head-to-head competition at the core of our story when we tried to challenge that deal. Microsoft and Activision is another one. But when we move away from the horizontal merger context, then we get into a world where enforcers for some 40 years did almost nothing, like virtually nothing. And that opens the door for defendants to raise arguments and kick up dirt and kick up dust on the case by saying, hey, these legal theories themselves are invalid, Your Honor, let alone the facts before we even get that far. So we're hurt by past inaction by regulators. The point number two, big tech specific. The big tech playbook is pretty clear at this point. It's basically play nice now so that we can play tough later on, right? Well, if as a regulator, you want to try to get out ahead of things, not have to unscramble the omelet later on, as you heard this morning, you're going to have to go up against a big tech company when it's still in the play nice phase. And that probably means they've still got the public on their side. And the judge is going to have a hard time seeing the future, right? It just complicates things, right? So you can, as a regulator, wait until we get into the play rough stage. I would say arguably the FTC's case against Amazon falls into that camp. Now you're dealing with a world, though, where the defendant's conduct and its power have become normalized. So you're trying to say to a judge, hey, yeah, okay, Amazon's been, for instance, the leading online superstore for maybe 20 years, but that's not normal. That's not the way the world should work. Yeah, that's a tough uphill battle to fight. That's point number two, this big tech specific. Point number three, you've heard, and I'm sure you all know, about the near total inaction by regulators at the federal level for some 2 decades when it came to big tech. As my colleague John Quokka mentioned earlier, I think big tech firms have made more than 1,000 acquisitions. And there were 0 challenges ex ante filed by federal regulators up until, past 2020 into the Biden administration. What that means then is any challenge to any big tech deal creates this total media circus because it's something new and something unusual. And that's largely unhelpful, I think, to regulators. You're trying to tell a serious, straightforward story to a judge. All the media frenzy becomes an unhelpful distraction. And then finally, these companies really do have, frankly, staggering amounts of money and power, and they wield the full brunt of it against regulators. They try to game regulators against each other. They will plant stories in the press. They will try to exert influence on lawmakers. And if nothing else, in litigation, they know they could outgun us at least 10-1, if not more. Federal courts really also haven't shown much willingness to rein these companies in during discovery. Think, for instance, of the FTC's case challenging just 2 acquisitions by Meta, that's Instagram and WhatsApp. That's on track to take 5 years or more just to get to trial, setting aside the inevitable appeals. That's really a judge letting a company, I think, take the reins and not controlling litigation to keep it moving. All of those are serious, serious problems. All of those lead to my headline proposal or recommendation. That is, I would strongly recommend that the state of California take some action to enact its own merger control law. So that's a response to the merger expert report, which I thought was very careful, very well done. Even just mirroring the federal Clayton Act, Section 7, I think would be very helpful because it would allow California courts to develop their own body of law that could, I think, be more sophisticated, frankly, and do a better job than federal courts have done. That said, I would recommend tightening up the language of that general statute in a couple different ways. I'm happy to drill down on those if it would be helpful, but I've also submitted some written comments that expand on exactly some of the proposals I would suggest. That's mergers. Let's talk about the technology platforms report, which again, I could not commend enough. I thought it was really even-handed, really balanced. I thought it was very thoughtful. And it did a really nice job summarizing a very, very knotty, complex issue. Look, I would make the same headline proposal. I think that the state of California do something. The argument that the market will just fix itself, I think, bears less and less even resemblance to reality with each passing year. That's the argument for maintaining the status quo. Hey, Facebook supplanted MySpace, Google supplanted Yahoo. I would just ask myself, how long are you willing to tolerate a monopoly? I think Facebook's been a market leader for more than 15 years, about as long as Apple has been in smartphones. Google's been the market leader in online search for, I think, almost 25 years now. Amazon online superstores looks to me about the same, 25 years. And Microsoft's been a market leader in desktop operating systems for some 30 years and counting. So how long are we willing to tolerate a monopoly and let the market fix itself? In the long run, sure, but hey, in the long run, we're all dead, right? So I would counsel against just letting the market fix itself, maintaining the status quo. I think that is not a realistic solution. I would affirmatively recommend that proposed framework that was sketched out on a slide by the presenters from the expert report on technology platforms group. And I think that's likely to do significantly more more good than harm. I think speaking from firsthand experience, seeing the facts on the ground, there is a massive amount of harm that is actually occurring right now because of these big tech firms' dominance. And it's not just quality harms of the sort that the representatives from Yelp were describing, but it's sky-high fees. It's take rates that approach 50% in some cases, which is a commission rate that's unheard of, basically, outside of the big tech sphere. I mean, think about paying realtors that people grumble about 6% commission rates. That's nothing compared to what these firms are taking, right? Distorted innovation, I could drill down on that if it'd be helpful, and more. I think even an imperfect
Professor,
solution. Yeah.
Sorry to interrupt you. You're at the 10 minutes, and if you could indulge us and wrap it up, we very much appreciate your comments.
Absolutely. In fact, I was right in the middle of my very last sentence, so perfect timing. Even an imperfect solution, I think, could yield significant benefits.
Thank you. So the panelist portion has concluded. Next on the agenda would be an opportunity for our experts to have any comments in response to what they just heard. Some of the comments were specific to the expert reports, and the idea is that you would have an opportunity to respond if you so choose. So do we have any takers? Professor Krishnamurthy?
Sorry, from Professor Barnett. I would just reiterate, I think what was one of his last points is that when you think about tech platform specific regulation, it's not really antitrust anymore. Now those frameworks are direct regulation framework, the way that the FCC regulates telecommunications or the way the FERC regulates energy. You need very specific rules and rulemaking to make a system like that work. What are the interoperability provisions that the tech platforms have to provide to each other? That can't be decided by litigation. So you have to go all in a regulatory structure if you want to create law that works in that way. That's an important aspect to consider.
Professor Quokka?
Let me second that comment and go a little bit further, which is to say that some of the discussion that I heard from the parties seemed to offer the solid recommendation that we continue to use rule of reason and ex post evaluations. And that is the norm for many antitrust violations, but it has its limitations, as Prasad just mentioned. But let me frame it as follows. When faced with an potential antitrust violation, and when it's difficult to predict ex ante what the outcome will be to the satisfaction of a court, that's point one. And secondly, if it is cleared so that no action is taken against it, so it's difficult to reverse after the fact, then settling for or urging rule of reason as the method of evaluating and proceeding is really to open the door to all sorts of things that end up being baked into the ex post market structure. So this is a classic old-fashioned discussion between rules and discretion in administrative law, as you all know better than I. And it is the reason why we have actually regulatory apparatus to govern certain types of industries and certain types of decisions that they make, where it's difficult to predict with any certainty ex ante what the outcome will be. And if allowed to persist, then it's very difficult to reverse it. So this is the reason for the DMA. I don't stand here to advocate the DMA, nor is anyone advocating, I think, the DMA in its entirety for California. I think that's a red herring. The issue is whether self-preferencing is something that needs to be addressed. And self-preferencing and some of the other conduct issues that were raised by the tech companies are extraordinarily difficult to fashion rules through the antitrust process, remedies, if you will, that are actually effective and enforceable. I've spent a lot of time looking at merger remedies, and the study that I've done has demonstrated that these so-called conduct or behavioral remedies, rules, not divestitures, but rules saying thou shalt not do this or thou must do that, are almost always ineffective because it is always in the enormous incentive of the companies to find workarounds, and they eventually do. They have every incentive to figure out a way where the language of the remedy is vague or doesn't allow for certain things, devices, to finesse the stated language through their own strategic behavior. So the agencies, I think, as I was there, I worked on this, the agencies have moved away. This was happening beforehand, but they've moved away firmly against the use of these sort of remedies. And the remedies are part of the process that we're stuck with. This is what has been used over and over again to allow for certain things to persist. And again, we're faced now with a lot of the consequences of a lot of lax past enforcement practices, saying that we can maybe fix it afterwards or the remedies will suffice. And time and again, as John Newman has pointed out, these have simply not sufficed. It requires more affirmative action ex ante. And yes, it requires some regulatory apparatus in order to deal with some things where the traditional antitrust process is not well suited to deal with. And in my personal estimation, let me make clear again that I hear I'm speaking personally and not for the working group.
Else from our panelists?
I'd offer one comment. There's some back and forth discussion about the rule of reason, and there was a suggestion, I believe, by Professor Barnett that, look, the rule of reason is prophylactic. It's been in place for a very long time. That's true, but as a practical matter, and now I'm giving you my practitioner's view, both doing plaintiff and defense side cases, the reality is that most federal judges default to the full rule of reason, because even though there are some cases that say you can short circuit, as Professor Barnett suggested, the full rule of reason, most federal judges aren't willing to do that. They want to see a fulsome record because they want to protect themselves on appeal if they get it wrong and they apply a more truncated rule of reason where they let the plaintiff get a certain presumption or bypass the full-blown analysis. They're worried about reversal. And in fact, we've seen that. The US Supreme Court, in a very large litigation, the California Dental Association case, did exactly that. You had courts here in California and then the Ninth Circuit Court of Appeals say, this is a situation where we should have a more truncated rule of reason. And the US Supreme Court said no. And the problem under the federal law is it's so unclear. The default is we need full rule of reason. Full rule of reason equals very expensive economists and makes it very challenging for most plaintiffs to bring suit.
Commissioner Simpson?
I'm an expert on school finance, but not on antitrust law. Could you just give me like a simple description of what the rule of reason is?
Sure. So rule of reason basically says, well, let me back up a minute. There's basically two ways that most antitrust cases in litigation are analyzed. We have a certain smaller set of conduct, like horizontal price fixing among direct competitors. We know that's bad, so we know that's subject to a per se analysis. If you prove the existence of an agreement among direct competitors to price fix, you don't need to go through a market analysis. We presume there's harm to competition. That's where the government, even during the Chicago School era over the last few years, 20, 30 years, spent a lot of its resources going after cartels. Rule of reason is different. Rule of reason is, okay, we don't have anything quite that extreme, but we're worried that there's an exclusive dealing arrangement between one large company and another. How do we analyze that? And what the courts have come up with is a balancing under what's called the rule of reason. And the plaintiff has the burden of showing that there's an anti-competitive effect that flows out of that, let's say, exclusive dealing arrangement. That's just an example where there's higher prices or reduced choice or some harm to competition. The defense gets to put on a justification, some kind of pro-competitive justification and evidence. And inevitably, we end up with typically a battle between economists on both sides of a case like that, where they try to convince the judge, ultimately a trier of fact, if it ever gets that far, do these cases do, where does the anti-competitive effect significantly or substantially outweigh the pro-competitive justification? And one of the issues that's happened over the last 30 to 40 years is for a plaintiff to be able to present that kind of evidence, they need to spend millions of dollars developing, going through terabytes of data, and then hiring an economist to analyze the market effects of the agreement. And that is an insuperable barrier for many. And then the defense, who's usually very well heeled, they put on their own market evidence, their own economists, and a federal judge without any guidance beyond just the general statute and the case law has to decide, am I going to let a jury figure this out or not? And as you heard from Professor Newman, the vast majority of the time, the answer is no. They dispose of it either on a motion to dismiss or summary judgment.
And the alternative way of dealing with this behavior, collusion or whatever, alternative to the rule of reason is?
You could create certain presumptions based on conduct. That's, for example, what the Single Firm Conduct Committee Working Group has suggested, that there's certain types of conduct that we think you should create a presumption legislatively, or the legislature should create a presumption to give guidance to the court to say, look, if you see this, then let the plaintiff bypass all of that, or the enforcer bypass all of that expensive market hurdle, and presumptively that's going to be viewed as anti-competitive. That doesn't mean the defense doesn't get a defense, they do, but the burden will be on them under their proposal to explain why this is justified instead of putting the burden the other way around.
Okay, so it shifts the burden of proof basically from the plaintiff to the defendant.
That's their proposal, yes.
Okay, thank you.
Thank you.
Could I add something, Commissioner, just briefly, and that is presumption. Yes, presumptions have a role in merger analysis too. As I discussed before, I asked some folks who are on the other side of many cases I've been involved in, how many mergers to monopoly are not anti-competitive? So if we had a presumption against those, I think as a matter of theory, as a matter of economics, it would make few, if any, errors. And indeed, the rule of reason process, the wholesale evaluation with all the armies of lawyers and economists, my colleagues involved, doesn't always get it right either. Often the error rate, as I described, is shockingly large in terms of correctly identifying anti-competitive mergers. Thank you.
Can I make a comment about self-preferencing? Aaron?
Yes.
We were talking about self-preferencing bans, and I think what we're trying to convey in our written submission and our comments here is that we're familiar with this ex ante approach. It's playing out in Europe. A self-preferencing ban is a core part of DMA, and it's the beginning of this shift that we're seeing in competition policy in certain jurisdictions, which remain an outlier away from consumers and toward producers. And we're starting to see some of the immediate effects of that, where a handful of intermediaries do get propped up, but a wide range of direct suppliers like restaurants, hotels, and airlines are having less visibility. And these are issues, as was mentioned, the FTC looked at here in the US for 2 years, and found that these are innovations that benefit consumers. They may harm producers, but as long as antitrust law is focused on protecting consumers, that will benefit the wider economy, consumers, and the small and independent businesses. Thank you.
Shall we start with Zoom and then in person?
That works. So currently we have 9 people with their hands up on Zoom. The first person on that list is Catherine Bracey. And she.
Kristen, how much time are we allocating to each person commenting?
There are 9, well, now 10 I see. There's another hand that just went up. So there were 10 total attendees on the Zoom.
So that's 50 minutes if they do 5.
I'm sorry?
Okay, I don't have access to the timer right here. If you want to, okay, just let me know. Thank you. And
we do want to leave.
Okay. Yep. And Catherine, I believe, is ready to speak.
Yes. Can you hear me?
Yes.
Great. Hi, my name is Catherine Bracey. I'm the founder and CEO at Tech Equity Collaborative. And I want to thank the CLRC for the information you've shared today and also for providing this space for public input. At Tech Equity, we envision a world where the tech industry is responsible for building widespread economic prosperity and is held accountable for the economic harms it creates in our communities. We study the way that the tech industry's products and practices impact the economic well-being of everyday people, particularly in the areas of housing and labor, which are two areas that are critical to people's lives and where the tech industry is having an outsized influence. Through our research, we've come to understand that much of the harm caused by the tech industry in these critical areas stems from the inordinate amount of power and influence that tech companies are allowed to amass. If we are to ensure that technological development is improving the human condition rather than undermining it, we need legal frameworks, either specific to tech or generally applicable laws that include tech, that account for the harms that can result when companies become unaccountably powerful. As the global home for the tech industry, California has outsized influence to ensure this critical industry develops in a way that creates broad-based prosperity for people around the world. And in order to do that, we need competition and consumer protection regimes that are fit for purpose in the 21st century economy. The kind of dominance that big tech has in the economy, and this is dominance that goes beyond traditional conceptions of price control into areas like labor rights, privacy, and public health, was unimaginable when the Cartwright Act was conceived. So to that end, I encourage you to take a wider view as you consider recommendations that take into account the realities of the modern day tech industry, including urging you to take workers and other affected stakeholders besides just consumers into account, and also urging you to consider the unique role that the venture capital industry, which is a topic I haven't heard broached today, that the VC industry plays in encouraging monopolistic behavior in the tech industry, and how the state may catalyze more competition in the funding ecosystem as well. In his remarks earlier, Professor Barnett asserted that the sheer size as measured by GDP of the tech sector in California justifies the status quo, but there are millions of California workers, students, parents, voters, renters, and small business owners who would beg to differ that the status quo is working for them. The sheer size of the tech sector is not an indicator of the health of California's markets. His comments, along with some other comments today about the fear of companies leaving the state if they have to comply with stricter regulations, reflects a rhetorical strategy on the part of big tech who want to maintain their outsized level of control over markets. But to echo David Kesselman's comments earlier, we believe that without competition and a better balance of power in the tech ecosystem, innovation cannot flourish. In order for California to remain the world's leader in breakthrough technology, we need an antitrust regime that accounts for modern day concentrations of power. Thank you very much for this opportunity to provide your comment.
So the next speaker is Hannah Walker. I'm going to Hannah, you have the ability to speak now?
Yes. Can you hear me?
We can hear you.
Wonderful. Hello, my name is Hannah Walcher, and I am the Executive Director of the California Independent Booksellers Alliance, a trade organization whose mission is to promote the vitality, diversity, and prosperity of independent bookselling throughout California as essential to the life of our communities. Our alliance has recently added our name to the letter provided by Economic Security California in response to the Tech Platform Report. You should also have other written statements from our members provided to you today. Now I will be reading a statement on behalf of our member, Emily Otenreith, owner of A Seat at the Table Books. A Seat at the Table Books, a small indie bookstore cafe just south of Sacramento, has struggled very much to find our footing in a market held in a chokehold by Amazon's predatory and monopolistic practices. And we're not alone. The decline from 7,000 to 2,500 indie bookstores directly correlates with the rise of Amazon. This is an immeasurable loss for our country, one that could be prevented through stronger regulations. Bookstores are essential to our communities for many reasons beyond our curation of books that matter to our communities. We often operate as crucial third spaces where people can connect with each other in truly meaningful ways, find a quiet place to read, and learn more about themselves and others. If you do not enact policies to prevent further market consolidation, you will be directly responsible for contributing to our decline and ultimate demise, and for the resulting harm to the communities you serve. Thank you.
Thank you. The next speaker is Natalie Schumann.
Hi there. Can you hear me?
Yes, we can.
Hi, my name is Natalie Schumann, and I'm speaking on behalf of the Writers Guild of America West.
Apologies. That was a misclick. Sorry, Natalie.
No worries. You can hear me now.
Yes, thank you.
I'm Natalie Schumann. I'm speaking on behalf of the Writers Guild. We represent thousands of writers of movies, television, and streaming series in California's vital media and entertainment industry. In addition to the materials that we've submitted for the record, we are pleased to address the Commission today about the state of consolidation in our industry. Our members experience the harms of unchecked consolidation firsthand, and we have been speaking out on this issue and advocating for antitrust reform for years. Decades of consolidation have transformed our industry into one dominated by just a handful of companies, including Amazon, Netflix, and Disney, who abuse their position of dominance with workers, consumers, and competitors and threaten to consolidate even further. Deregulation and antitrust under-enforcement have allowed waves of harmful mergers between behemoth media companies and vertical integration that cuts out competition from independent producers, leaving just a few dominant firms with tight control over the content that our industry produces, often from the time an idea is conceived until it reaches audiences worldwide. These few dominant firms have used their increased market power and vertical control of content production and distribution to disadvantage their competitors, raise prices for consumers, limit creative innovation, and push down wages for creative workers. Writers have experienced these harms firsthand as their employers leverage this oligopsony power to worsen compensation models and employment practices that had been industry standards for years. Pay and working conditions became so dire that in 2023, 11,500 writers went on strike for nearly 5 months to fight for their ability to make a living with their valuable work. Writers won significant gains in that strike, but the landscape of excessive concentration among their employers is only getting worse. In the streaming market, instead of dynamic competition, we see all the major firms raising prices and reducing content spending in parallel, leaving consumers to pay more for less. Despite these already anti-competitive conditions, Wall Street continues to demand even more consolidation. And without government intervention, more harmful mergers and anti-competitive conduct are on the horizon. With its recommendations to the state legislature, the Commission has the opportunity to push back against further consolidation and strengthen competition in this vital California industry. We urge the Commission to recommend strong reform of the state's antitrust law that prevents further consolidation that would harm workers in the media industry. Specifically, state law and enforcement must include consideration of worker impacts in mergers, disregard attempts to quote-unquote offset consolidation's harms, and it should lower barriers to prove antitrust violations. The state should also pursue increased enforcement against abuses of dominance, conduct merger retrospectives and market investigations, and empower the state's antitrust enforcers with clear jurisdiction to regulate anti-competitive behavior. We've submitted for the record several of our research reports and comment letters about mergers and competition issues in our industry, and we thank you for the opportunity to comment.
Thank you. The next speaker is Lee Hepner.
Hello, hi, good afternoon, commissioners. My name is Lee Hepner. I am Senior Legal Counsel for the American Economic Liberties Project. We are a nonpartisan organization that advocates for rigorous enforcement of the antitrust laws and for policies that enhance the fairness of our economy. We do not accept any corporate funding for our work. Having sat through every single one of these meetings now for the past 18 months or so, I'm further convinced that the single most important thing this commission can do is to recommend an abuse of dominance standard that includes specific bright line rules against certain forms of anti-competitive conduct. That would be a single firm conduct law for the state of California. And those specific prohibitions can include conduct that courts have already found to be illegal. Exclusive agreements imposed by dominant firms have been deemed illegal by the courts. We can codify that. Self-preferencing is how Google entrenches its own dominance and should be categorically illegal under an abuse of dominance standard. You've heard from Google twice today, once from Mr. Benjamin and again from Professor Barnett on behalf of the Chamber of Progress, which is a Google-funded lobbying front. Google has already been found liable for violating federal and state antitrust laws in the Epic v. Google App Store case, but that litigation took years to resolve. Bright line rules would have encouraged compliance without the need for enforcement, and it would have shortened the 4 years it took to decide that case, while Google profited from its monopoly conduct. I agree with the earlier presenter on the working group report. I believe that was Mr. Kesselman. I may be wrong, that a single firm conduct standard applicable to all industries would be a huge step forward, but that the federal standard on its own hinders enforcement. And I agree with Professor Quokka, who I'll paraphrase as saying that really what we're having here is a debate between rules and discretion. And we should all favor rules that are clear, that favor compliance, and that don't take 5 years to enforce. The rule of reason, which you've heard about toward the end of today's conversation, is, despite its name, a discretionary standard, and it makes the law challenging and very expensive to enforce. That has resulted in significant under-enforcement of the law, and this commission is well positioned to recommend a fix to that problem. This commission can and should adopt a single firm conduct standard, the abuse of dominance standard, that includes bright line examples of abuse of dominance. And let's be clear about a couple of other things. New regulation to prevent anti-competitive conduct does not hamper innovation. It combats the monopoly power that crowds out innovation. And we don't need to mimic European law to get there. I believe that's another red herring. California can do its own policymaking through its own legislative process. Contrary to the assertions of Google's representative, Mr. Benjamin, antitrust laws were intended to protect competition, not just consumers. Competition exists, consumers, workers, and small businesses benefit. I also encourage this commission not to act out of a baseless fear that businesses will flee California. That is a talking point perpetuated by special interests who think the status quo is working where it is not. This commission should not be recommending policy based on any fear that it might not pass in the legislature or that businesses might move to Texas. Those are political constraints for other bodies to figure out and are irrelevant to a discussion of the right policy for this body to recommend. One final point on pre-merger notification, which you heard about at the outset of your presentations today. California has already gone further than the Uniform Law Commission's proposed law on pre-merger notification, which fundamentally undermines state and federal efforts. A coalition of a dozen labor, consumer rights, and anti-monopoly organizations sent a letter to this commission back in December where we highlighted how California has exceeded existing pre-merger notification rules with respect to the grocery industry and the healthcare industry. Professor Newman was right on this point. We should also be scrutinizing vertical mergers, where companies are situated vertically on a supply chain with the same rigor as horizontal mergers between companies in direct competition with each other. The ULC's pre-merger notification proposal does not address this. Our alternative proposal would, and I encourage the commission to revisit our letter from last December. I believe that's the end of my comment. Just one last thing, there's a desire for balance undergirding a lot of what this commission is discussing. And I fear that what this commission is balancing against is a proposition that we shouldn't do anything. And that proposition is coming from corporations like Google, which have already been illegal monopolists under federal and state law. We were not invited to present an alternative proposal to the commission today. Google was invited to present two. That is not balance. It is incoherence. I really encourage this commission to cabin the comments of the Chamber of Commerce or Chamber of Progress or Google or any other illegal monopolist or entity funded by an illegal monopolist in their discussions around antitrust reform in California. And thank you so much to the commission for your consideration.
Thank you. The next speaker is Doni Tedesse.
Good afternoon, everyone.
Just a moment.
Before we move, I believe we've been.
Is your mic on? I don't know. Mr. Hebner, there was a question from the chair.
Mr. Hepner, thank you for joining us. My understanding is staff issued an invitation to join us on a panel in August, I guess, our next meeting. Is that correct?
Yes.
That may be the case. Clarify, however, that this commission hears only 4 presentations. And I assume that it will strive for the same balance that it attempted today, which included 2 presentations by an illegal monopolist. So to the extent that there is room for more organizations to present formally to the commission, that is fantastic and appreciated, although I assume that we will also be prioritizing the most effective presentations for the commission's limited time.
We are open to hearing all points of view, and we're delighted to hear further from you in August. Kristen, who's next?
Tony Tedeschi? Are you?
Yes, I'm here. Can you
Yes,
hear
ready
me?
to go. Thank you.
Great. Good afternoon, commissioners. My name is Doni Tedeschi. I'm here representing Rise Economy. We're a member-led alliance of around 300 nonprofit organizations throughout the state dedicated to creating systemic change and bringing economic justice for BIPOC and low-income communities. We focus on combating the legacy of redlining in these communities by holding banks accountable for their role in creating community-centered economies. Our work is largely guided by the Community Reinvestment Act, which creates a duty for banks to reinvest in communities where they take deposits, including low and moderate income communities. I'm here today to elevate 2 areas of concern from our coalition. First is the lack of adequate state-level scrutiny over the merger of state-chartered financial institutions. And second is the proliferation of financial technology companies that are functioning much like traditional banks, but are not regulated as such and not subject to reinvestment obligations via the federal CRA. Rise Economy members and allied organizations have found the federal bank merger process to be a significant opportunity to insert community voices into considerations about whether and how bank mergers will affect key stakeholders in impacted neighborhoods. Since 2020 alone, we've negotiated over $100 billion in reinvestment commitments for California with merging banks in the areas of homeownership, affordable housing, and small business development. Despite this, we recognize that bank mergers can do irreparable harm to communities and that the current bank merger process, both at the federal and state level, is strongly biased in favor of merger approval and lacks sufficient safeguards to protect consumers and communities from the excesses of corporate power and consolidation. The vast majority of bank mergers are approved, even when there are significant concerns from community groups and members. And unfortunately, the DFPI, the Department of Financial Protection and Innovation, lacks the regulatory authority to adequately scrutinize these mergers. As a result, we've seen communities suffer in the form of lost jobs and reduced hours and working conditions for community development and frontline bank branch staff, closed branches, decreased reinvestment activity, reduced access to credit for small businesses, higher costs and fees for bank customers and consumers, exacerbation of climate change concerns, and greater climate-related financial risks to the financial system. Also, mergers that are not adequately scrutinized can pose and have posed significant risks to the broader financial system in California. The failures of Silicon Valley Bank and First Republic Bank, as examples, suggest that greater regulatory oversight is needed to ensure state-chartered banks are stable enough to serve their communities. Another dynamic we're increasingly concerned about is the proliferation of financial technology companies. Fintech companies have seen an explosion in market share as our reliance on technology increases. Apps like PayPal, Cash App, Venmo allow users to send payment directly to others and companies and hold funds similar to a bank debit account. However, where a traditional bank has a reinvestment obligation through the federal CRA, none exists for fintechs. Notably, some apps like Cash App have a disproportionate or higher usage rate by Black and low-income borrowers. Additionally, while deposit-taking institutions like banks insure deposits of their customers through the FDIC, the rapidly growing number of payment app users are left vulnerable to losing their funds without deposit insurance or other consumer protections. Companies that offer such bank-like products have become ingrained stakeholders in the financial services marketplace and thus should be subject to bank-like obligations and accountability. Rise Economy, our members and allies have long called for state-level policies, much like the federal CRA and the Bank Merger Act, that would, among other things, equip the DFPI with more authority to scrutinize and even reject mergers in cases where communities would be worse off, respond to the ever-changing financial services landscape, and properly regulate and extend reinvestment obligations to financial institutions not covered under the federal CRA. And lastly, further the stability of the California financial system. A state-level Community Reinvestment Act, for example, could allow the DFPI to prioritize convenience and needs of communities such that no bank merger is approved unless bank applicants demonstrate that communities would be better off after the merger. It could also democratize oversight and accountability of financial institutions by allowing for meaningful public participation in the process of examining whether these institutions are meeting community credit needs. At the very minimum, state law should make it so that no merger is approved unless bank applicants can demonstrate that the combined bank will reinvest more in communities, have better consumer protection, fair housing and fair lending policies and practices, provide stronger mitigations against the advance of climate change, and show reduced climate-related financial risks that each bank had separately and independently. Recently, states like New York, Illinois, and Massachusetts have passed laws to meet the needs of low and moderate income communities and increase the integrity and accountability in financial services. The CFPB has also put out a summary and analysis of various state regimes.
I'm sorry to interrupt. You're at 5 minutes, so if you could wrap it up very quickly, we really appreciate your comments.
Great, thank you. One more sentence left. The CFPB has also put out a summary analysis of various state regimes indicating there's a national momentum for this kind of regulatory oversight. As the fourth largest economy in the world, California should not fall behind in ensuring that consumers and communities are protected from bank consolidation and under-regulated fintech companies. We urge the commission to make these recommendations. Thank you.
Thank you.
May I comment on the public comment? I appreciate it because I think that I would appreciate seeing analysis or speakers regarding other industries. And he was talking about the banking and financial services industry, not just big tech. So if I could make that request too, for this commission to hear from those experts in that industry. Thank you.
The next speaker is Carmen Comsty.
Good afternoon, and thank you, commissioners, for your ongoing work on this important subject. I'm Carmen Comsty, Lead Regulatory Policy Specialist with the California Nurses Association. CNA is the largest labor union representing registered nurses in California, with over 100,000 registered nurse members who provide direct care to patients at the bedside across the state. The healthcare sector, particularly the hospital industry, has had a high level of merger activity in recent decades, which has resulted in a concerning level of market concentration that harms both workers and patients. In the material CNA has provided to the commission, you can read more about the evidence regarding healthcare concentration through horizontal, vertical, and cross-market mergers and the negative impact that health firm consolidation has on healthcare prices, wages, and quality of care and quality of jobs. Research literature demonstrates how healthcare sector consolidation has not improved patient care and is associated with higher hospital charges, wage stagnation, and cuts to staffing, harming patients, nurses, and other healthcare workers. In other words, consolidation in healthcare markets can have life or death implications for California's patients and workers. We support a number of reforms to strengthen California's antitrust law, including the expansion of pre-merger notice beyond federal thresholds and the establishment of clear AG authority to challenge transactions under state law. Importantly, we urge the expansion of regulatory and AG antitrust review authority to include a broad range of transactions and broader theories of anti-competitive market harm, specifically market harm and labor market harm and non-price theories of harm. CNA has included a detailed brief on recent efforts by federal regulators to develop labor market impact review and federal antitrust enforcement, including the FTC and US DOJ's adoption of Merger Guideline 10 and the non-compete rule by the FTC. Merger Guideline 10 recognizes that mergers can result in lessening competition for workers as sellers in the labor market by both slowing and reducing wages, and importantly, by reducing workplace or job quality. The inclusion of reduced job quality as a factor in federal merger review highlights that labor market monopsony can negatively impact the bargaining power of workers, working conditions, and other non-price, meaning non-wage terms and conditions of employment. There are several recent federal merger challenges that raise labor market theories of harm, notably Albertsons Kroger. This case in part challenges the proposed merger between these two national grocery chains because union workers' bargaining power would be diminished to the detriment of the grocery workers and their union's ability to bargain for better terms and conditions of employment. Finally, I want to highlight the recent work of California's Office of Healthcare Affordability. This office, pursuant to their enabling statute, has established cost and market impact review regulation, which would review healthcare entity transactions that had a material change, including some single firm conduct. The office's review includes both an impact analysis on healthcare workers and as well as an impact analysis on patient access to and quality of healthcare. While the office does not have blocking authority, it does have authority to review and investigate healthcare market failures. These developments within the Office of Healthcare Affordability demonstrate that broad merger review and review of market failures at the state regulator level can indeed be established under California law, and that California is capable of developing standards to address and prevent harm to both workers and consumers as a result of anti-competitive consolidation. Thank you again for the Commission for its ongoing work to strengthen California's antitrust laws.
Thank you. Kristen, before we go to the next speaker, I know that at some point we're going to lose Commissioner Kubas, and I just wanted to make sure
At 4:30.
4:30. Just want to make sure we've registered her comment about other industry
Yes.
input. The project was scheduled, was organized, what, a year and a half ago to focus as it is. But we can still deal with the other industries through targeted inviting of speakers, even if there aren't formal panels.
Yes, and in the first meeting, we did hear the concentration in California report, which surveyed several different groups. So yeah, that is something I've been in ongoing dialogue with Cheryl and our staff. So I think your input.
We've heard healthcare and agriculture in particular raised occasionally. It would be, I think, helpful to the commission's thinking to have a few people come in and talk to us about that, given their importance to our economy. Thank you, Commissioner. Kristen, who's next?
Thank you. Next, we have Elena Trucker.
Good afternoon, Commissioners. Can you hear me?
Yes.
Yes.
Good afternoon. My name is Elena Trucker, lead buyer and operations manager for Napa Bookmine, an independent bookstore with 2 locations in Napa County. We make our living off of books, but books are a loss leader for Amazon. They buy in bulk and can sell at an incredibly cheap price that no brick and mortar store can compete with, and use the data collected from book sales to conduct market research that undercuts local businesses. Their goal is to make Amazon the only option, at which point they can raise prices with impunity. They can afford to do this because their marketplace is not a separate business from their cloud computing services. If Amazon were required to separate these businesses, it would quickly become apparent that Amazon's book and third-party seller marketplaces do not represent fair competition with other retailers. We routinely see people wandering our stores to find books they want and then buying them on Amazon. Publisher consolidation has forced our bookstores to carry products we don't believe in from suppliers who have so much power that they dictate the market itself. Additionally, it's not difficult to see how AI could soon replace most jobs in our industry if its reach is not reined in by legal means. Technology, of course, provides opportunities, particularly for consumers who live in rural or underserved areas, but a website is no replacement for a thriving, locally owned business that employs community members and provides services such as donations to local schools and nonprofits, school book fairs and classroom materials, and sales tax revenue to support the city and county's operational health. I want to stress that this is not a bookstore problem. It is a systemic problem faced by all small businesses. We are forced to compete on an unlevel playing field with behemoth tech companies who continue to get bigger through mergers and acquisitions and then artificially lower prices. Because of these conditions, small business profit margins are razor thin, and because of that, our wages are depressed. Because our employees make less than they deserve, they have no disposable income to spend, thus hamstringing the growth of our economy. This is everyone's problem. Thank you.
Thank you.
Thank you. The next speaker is Malika Manarsada.
Hello. Hello, commissioners. My name is Malika Manarasada, speaking on behalf of HEAL Food Alliance. HEAL stands for Health, Environment, Agriculture, and Labor, and we are a national coalition of 43 organizations representing over 2 million rural and urban farmers, ranchers, fishers, food chain workers, and more. Together, we work to transform our food systems for the health of our communities and the planet. HEAL is based in Oakland, and 14 of our organizations are based in California. Over and over, we hear from our members about how corporate consolidation is affecting them and how the lack of antitrust enforcement specifically is hurting workers, farmers, and rural communities. Right now, giant corporations are reaping record profits, while workers, especially those on farms and in meatpacking plants, face increasing injuries and sometimes death due to things like escalated line speeds, heat stress, and pesticide exposure. Meanwhile, small farms are being driven off the land in record numbers. Right now, 6% of farms own 35% of farmland, and Black land loss is continuing at unprecedented levels. These small farms tell us how challenging it is to compete with corporations due to price fixing and other harmful practices. Additionally, the pandemic and the formula shortage both showed us that a consolidated food system is a fragile food system. We need decentralized, community-controlled food systems in order to survive the next shocks. By cracking down on harmful corporate practices, reversing consolidation, and prioritizing small independent food operations, we can also increase protections for workers and build a sustainable, nourishing food system for people and the planet. Today, we urge you to advance aggressive reforms to our antitrust legislation to stop the issues we are facing today. Thank you.
Thank you.
Thank you. The next speaker is Devin Gray.
Hi, everyone. Can you hear me all right?
Yes.
Great. Good afternoon. My name is Devin Gray. I serve as the president of End Poverty in California, or EPIC for short. I'm joining today to urge this commission to seize the opportunity to update the Cartwright Act and reform our incredibly outdated antitrust laws. Now, you've heard from several subject matter experts on the merits of this, but I'd like to offer a perspective from the point of view of everyday Californians, including the nearly 5 million living in poverty today. As an organization, we've spent the last 2 years traveling across the state to listen and learn from Californians about their concerns with our state's economy. We've spent time in over 20 counties now, and while our state is incredibly diverse and there are certainly region-specific challenges, some consistent themes across the state include that people are experiencing wages that aren't keeping up with the cost of living, a lack of assets upon which to build wealth, and barriers to entry for would-be entrepreneurs and small business owners. Now, people have a myriad of explanations as for why this is happening, but I think it would be irresponsible not to recognize that anti-competitive practices are among the main drivers here. And our partners at Small Business Majority, which is a research, education, and advocacy organization representing 20,000 very small business owners in California, conducted a poll recently of 500 small business owners, and their findings reinforce much of what we've heard from residents around the state. They include that 56% of small business owners say that one or more large companies dominate the market in their industry. And the same percentage agree with the statement that large companies have an unfair advantage in their line of work. Nearly half of small business owners polled agree that there has been an increase in monopolistic practices in recent years, and small business owners overwhelmingly believe larger companies have greater and better resources to take small businesses' creative ideas, mass produce them, and drown them out with their market power. And importantly, small businesses agree that our economy is changing and it's time to update our laws for the modern age. The consolidation of the internet marketplace among a handful of giant actors has certainly allowed for the largest firms to act as gatekeepers for any small business seeking to advertise or conduct business online. And while small businesses have always had to engage with third parties for advertising, this is an entirely different landscape. Whereas 50 years ago, businesses could advertise through a range of different platforms, they always had the ability to shop around. Now, if you don't advertise through Google, for example, you're at a significant disadvantage to your competitors. And this allows these large firms to essentially determine the price of entry into the online marketplace writ large because they are so much the dominant platforms online. And this obviously hurts the smallest businesses who will get significantly outspent by larger competitors and thus buried too deep in search engine placements. Additionally, the massive scale of online retailers allows them to price their products far below what smaller competitors can tolerate, too often pushing them out of business entirely. Now, why does this matter? Well, I think most of us here share the goal of having a state where everyone can participate in the market and have a fair shot at building wealth. But we obviously have a very long way towards reaching that ideal. And the fact is that today we have a racial wealth gap that's as wide as it was when the Civil Rights Act of 1964 was passed. And if we want to close the racial wealth gap and have a capitalism that works for most, if not all, Californians, we simply can't allow for corporate consolidation to continue to create insurmountable barriers to entry and an uneven playing field for the Californians who are determined to start businesses and create wealth for themselves and their community. So I urge this commission to recommend reforms that will strengthen our state's antitrust legislation and correct the harmful corporate concentration that has been so harmful for our workers, consumers, and small business owners. Thank you.
Thank you. And the final speaker that's got a hand on the Zoom is Bianca Blomquist.
Thank you so much. Really appreciate the work that you all are doing to elevate this issue and here for the small business perspectives. Devin, thank you so much for sharing some of our remarks. I wasn't sure that I'd be able to speak today, but I'd be happy to share some additional data points. Devin cited our research. We are a research and advocacy organization of 85,000 small business owners nationwide, 20,000 very small businesses here in California. In that poll that Devin cited, small business owners were also participatory in thinking about solutions to address consolidation, especially in the technology industries. So according to small business owners, a wide range of practices create an unequal playing field, such as self-preferencing, predatory pricing. Each of those, both self-preferencing and predatory pricing, has affected a third of the respondents in our poll. About a quarter of small business owners have been negatively impacted by other anti-competitive tactics utilized by technology platforms, including loyalty discounts, copycatting, forced advertising, and toll booths. But they're interested in solutions. Small business owners are ready to work with legislators to address these issues. Some of the solutions that they have indicated their support for include tax incentives that encourage more small business and entrepreneurship development. 84% supported that. And of course, better enforcement of existing antitrust laws at 80%, and prohibitions on predatory practices. So in order to compete, in order to grow their business, small business owners need these solutions that will address monopolistic and unfair practices and promote a more level playing field. I also want to uplift Carmen's comments as they relate to the Office of Healthcare Affordability and increased oversight over mergers in the healthcare industry. Small business owners support these measures, especially when they are not tied to any demonstrated positive outcomes. Small business owners are struggling to keep their doors open. 67% of business owners that do offer healthcare to their workers are struggling to afford it. Business owners of color are much more likely to indicate making a change to their benefits in response to the marketplace. So healthcare is absolutely a small business issue and a competition issue. I'd also like to uplift Donnie's comments on the rise and proliferation of financial technology companies. We are also seeing this. Fintech companies are skirting financial protections that we have worked so hard to put in place under California's Truth in Lending framework. As you all may know, California was the very first state to offer Truth in Lending framework to small business owners. And we hope that you will work with you in the legislature to strengthen those protections, build upon that work that we've created to protect small business owners from unscrupulous lending practices. So thank you, Donnie, for that comment, and to the commissioner for suggesting an additional conversation around the financial technology issues that we've been seeing. Thank you.
That was the final speaker on the Zoom that had their hand up. So we're all done with this public comment on the Zoom. That was it. We're all done with, yes. I don't know that your mic is on, so I just wanted to mention that.
I'm sorry. Yeah, I've got a booming voice, but apparently not that loud. I saw 3 hands up. Let's proceed based on how close you are to the microphone. That seems efficient. Please identify yourself, your affiliation if you have any, and then launch into it.
All right, I believe the mic's on. Great, thank you, commissioners. My name is Terry Oley. I'm the Director of Economic Security, California. We are an issues advocacy organization that is dedicated to building an economy that works for everyone. And we work on 2 main issues. The one that's pertinent today is that we look at the forces of the economy that are actually making it hard for people to have the resources and freedom to have the stability to thrive. And part of that we really attribute to the level of corporate concentration and distortions in markets that should be competitive, and competitive for consumers, but also for workers, for small businesses, for local economies, and then we believe for the economy as a whole. I'm going to make a couple points going back all the way back to the mergers and acquisitions discussion earlier today. I want to thank you, first of all, for all of your work, for the presenters, for the working group reports. There's so much to weed through, and I appreciate what a task that is. I want to just kind of go up a level and lift up a few things I heard today that seem really important. First of all, California really leads the way on pre-merger notification, and I would endorse the point of view that we should be moving forward and continuing to expand pre-merger notification and not be going backwards. Recent legislation in both healthcare and grocery stores allow us to have the kind of peek in to what may be happening as a in mergers that we really need, and that kind of standard should be expanded to other sectors overall, so that we can, and should be done in California, so that we can consider the impact and the information that is relevant to California. We also should be lowering the monetary standard and not relying on the federal standard as a threshold for reviewing mergers. As well, considering harms to workers, labor markets, and of course, looking at serial acquisitions that sometimes sort of skirt and are able to otherwise evade some of the standards that we otherwise have in place. Second point is expanding and changing the standard for reviewing mergers to be able to look at the public interest and not, which would allow for considerations outside what we kind of narrowly look at now, which is basically the consumer welfare standard or efficiencies. We need to really look at reversing the trend of the last 40 years. And I would submit that that's the reason that this commission is doing what it's doing right now, is because of the recognition by the bipartisan resolution a couple of years ago to say, you know what we've got on the books right now just isn't really working. And we need to look at what we need to do to address corporate concentration in this modern economy. Going now to tech, just to restate the obvious that some of what we're talking about today would have just been completely unthinkable, unimaginable to the people who drafted the Cartwright Act back in the day when robber barons and railroads were the industries we were talking about. But I think it's also relevant to consider that one of the early antitrust statutes that was at the federal level that came to be because of railroads that both wanted to be the carrier of the goods, but then also started to think, you know what, if we own the coal and the timber that we're transporting, that would be really good for us. We could give ourselves a good break on transporting those products. And when they started to buy up the timberland and the coal mining land, Congress acted and said, that's actually not all right. And we're going to structurally separate aspects of this kind of vertical economy so that we don't have the carrier also being the provider, the provider of the product. And that's something I think we can take as a model. And just even though that's so long ago, it actually applies today. To, of course, make another point that big tech is now more powerful than some of our democratically elected governments, just in terms of the power and the concentration, the ability. We heard multiple times today about how in a court, we are just completely outgunned by the power, the lawyers, the resources that big tech brings to bear. And we've seen little spats kind of play out in ways. I think I mentioned this in my public comments last time when Google was threatened by a, oh boy, I'm going fast. Google was threatened recently by a legislation that would have required paying out local journalists. They threatened to actually cut off news access for all of California. And I think we just need to really ask a profound question around whether that's an appropriate use of the kind of power we see in an industry and what we can be doing to curtail that. A couple of quick things. First of all, I love the idea of a robust single firm conduct standard and the idea that that would actually be the ring that serves them all, and it could actually help overarchingly not just tech but other sectors. I also think that one thing to think about as well is that there was a lot of discussion today about Congress and what is happening in the congressional legislation. I think that is interesting context, but we have seen in California that we need to act first. We tried to wait for action on net neutrality. We tried to wait on action on consumer privacy, and we ended up having to act as California. Congress was not, and in fact still has not acted on those important topics. And so I would say it is really incumbent upon us in California to take that action. And then finally, and I mentioned this in our written remarks, may have just been the timing, but there is very little mention of artificial intelligence and the way in which the big tech and the sector of technology is, the artificial intelligence is sort of supercharging, if you will, the concentration of tech. And I would really urge you to, as you're exploring as you're exploring over the next few months, to really think deeply about AI and what it means in terms of corporate concentration, since it is just further entrenching the dominant players and making it nearly impossible for a robust economy. And we all love the startup idea, but with the concentration that we have of the big players, it's basically impossible. And finally, I would reiterate a comment that one of my colleagues made around not being as concerned about the political reality of future legislation. I spend most of my time actually over in that building, and I think that a lot can happen between here and there. And I would just urge you to consider the merits of the policies that you're looking at, and we can worry about the politics another day. Thank you so much.
Yeah, just a quick question. Earlier in your comment, you said in reviewing mergers, we should consider public interest. How do you define that?
Right. Well, I think it's thinking, and I think there's maybe a lot of ink spilled on that topic already that we could go into, but I think the idea is that right now we have very narrow standards where we're looking at like just the consumer standard and like, how does this affect consumers? And is this good for pricing for consumers? And I think looking at a broader set of impacts, like what does this do to a local economy? We heard some comments from booksellers and things like that. What does this do to labor? And looking at overall, how does this actually play out in terms of benefiting a broader, an economy for a broader set of players, and not simply around pricing and consumers.
Okay, thank you.
Thank you.
Great, thank you. I'm here to help address Commissioner Kubis's concern for the need of other industries. I'm not going to talk about Google. I'm Dan Robbins. I work in the motion picture industry. I've worked there for 28 years. I wanted to respond to the comments of my colleagues in the Writers Guild. They made a couple of points. They mentioned that there's only a handful of companies in that business that use their oligopsony power to push down the wages of the creative talent we work with. It's actually quite a highly competitive sector. We have the companies, Disney, Universal, Paramount, Sony Pictures, Warner Brothers. In the last 20 years, we've had significant new entrants. Netflix came and brought in a whole new distribution system that was revolutionary. They were followed by Amazon Studios, Apple Studios. In Hollywood, we welcome the competition. They make a lot of good product. You've probably seen it, and others do too. We also have a very strong independent sector. These are companies that create, finance, and distribute their own content, like Lionsgate, Legendary, AGC, Film Nation, Lakeshore, Millennium Media. I could go on and on. So there's massive competition for the talent that consumers the most want to see in these pictures and streaming programs. So you may say, well, Dan, well, what about all the other participants in the sector? The folks that work, behind the scenes, or the actors that are lesser known. Our sector is the most heavily unionized sector in the world. We deal with 45 different unions and under 64 different agreements. We are constantly negotiating. These all have 3-year terms. So if you do the math, that's 15 deals a year. We're constantly redoing these, constantly giving raises, constantly increasing pension payments. Last year was a tough year. We had the dual strikes. To give you some sense of how infrequent that is, the last time we had a dual strike was 1960. The Screen Actors Guild was led by a vibrant young Democrat named Ronald Reagan. So a lot changed since then. But just to give you a few quotes, these come directly from the press releases of the guilds. When the Writers Guild deal was done, they said, we've achieved meaningful change. They got a 9% raise just since September, increases to health and benefits. For example, also, if you're the main writer on a picture that's over $30 million budget, your minimum is $100,000. And now we've also added in foreign residual payments, which bumped that up to $216,000. Before any of this, the average writer salary was $132,000. So, we already pay well. We're continuing to pay more and give more benefits. So I thought it was unfair to suggest there's this conspiracy to drive down the workers. We had a great deal with the Directors Guild. Similarly, they said it was a historic agreement with major breakthroughs for labor. My friends in the Screen Actors Guild said their agreement was transformational and the most significant in generations. They got $1 billion in additional wages and benefits, and they literally said it's their golden age. So I think they're doing fine, and we work to treat them fairly. I also wanted to mention they talk about harm to competition and raising prices. Competition is fierce in our sector. Also on the distribution side, we compete with, first off, there's 206 streaming services. That's a lot of competition. We also compete, the market leader in the space, in the over-the-top space is none of the companies I mentioned, but YouTube TV. It's ironic because one of the other speakers, one day before the Writers Guild wrote, one of the other speakers sent a letter to the United States Department of Justice Antitrust Division claiming that YouTube was going to clean our clocks and poor little Disney, Paramount, and Netflix wouldn't be able to survive unless the Department of Justice were to help us out. So I mentioned that because it seems inconsistent. Either we're in this position where we're not paying people well and being difficult, or we're barely surviving. Just a couple of other points. Sorry, their paper was 55 pages, so it's a hard task to capture it all so just 2 more points. One is some streaming services raised prices last year. Prices did go up. But if you look at the total price increase since 2019, it's 10%. And if you adjust that for inflation, it's -7. Prices have fallen. And then could I indulge you just for one more moment? Sorry. I also wanted to mention, they made a comment that we're suppressing innovation, which personally got me riled up because I do a lot of the tech work. I just walk you through some of it since I started at MPA. In 1996, we helped develop the DVD to improve over VHS. Quality went up, lots more consumer choices, a very competitive market. The next innovation is we moved from those bulky film reels that we used to have to circulate around the world to do theatrical. to a digital cinema system. That system has better quality, it has better sound, and it gets the product out to people a lot faster. So we're expanding output, which is a good thing in antitrust law. And just a couple more, obviously, the streaming is a major innovation. We also formed a not-for-profit R&D lab where I serve as the general counsel. The sole goal of that lab is to increase innovation in our sector for the benefit of everyone in it. And so we're doing a lot of work in these places, and thank you for letting me go a couple minutes over, but I wanted to let you know about that. And we'll also be probably submitting a paper because I disagree with the characterization of the sector in your working group's concentration report. I think it's mistaken. And so I'll be generating something in writing that sort of leads you through the mistakes I believe they made. So thank you.
Thank you.
Hi, you remember me? Well, thank you. Yes.
Well, she heard me. How come you can't? You're sitting right there.
Yes.
Of course, I remember you. You were here
Good
the last time we
afternoon.
convened.
Yes, good afternoon.
We changed location and you still found us.
Yes, and I changed my hat as well. So thank you, California Law Revision. Thank you so much for your time, effort, and energy and your servitude. My name is Angela Harris. I'm the founder of Wellness of Life. My business location is in East Sacramento. So I'm representing the small business owners today. And most importantly, I've been established for 30 years in the industry, and I've been in East Sacramento for almost 20 years. So therefore, I sell products at my clinic. I also sell online based on Google and also Amazon as well. And so the last month I attended the commission, as you know, and based on hearing the antitrust laws, I expressed my concerns in how these policies will affect me as a minority business owner. And I'm double minority, as you know, I'm female and then I'm of color. So therefore, sometimes people may use that, but it's important because as a small business owner, not all businesses survive the first 1, 3, 5 years, 10 years, and therefore I'm established. And because of certain aspects based on Google and certain online approaches, whether it's Yelp, helps us to develop our marketing strategy, even surviving in the economy based on whether it's inflation and being feasible during inflation. So therefore, thank you for giving me the opportunity to describe what helps energize the existence of small business survival. As a California established small business owner, my online presence is essential. So therefore, what happens is tech platforms like Google, Instagram, and Amazon are giant companies that have helped small brands like mine connect with consumers. Most importantly, it's also convenience. So when it comes to convenience, people may do these searches that helps our business and it doesn't cost us an enormous amount of money and it makes it more feasible for us to be able to survive, meaning our bottom line. So therefore, it helps us with our breakthrough, not our breaking point. I have now heard from several business owners who are also concerned about the proposals you are considering, and I hope you will consider the real world impacts that this potential changes would have in our livelihood, as that's also part of the whole picture. So sometimes what happens is people may express based on their perception and perspective. However, whole picture is so important because it also helps address other components that you may not be aware of. So because you have this power and you have this influence, if you, based on us being self-preferencing proposal breaks Google Maps, Google Business Profile in California, as it has in Europe, you will be breaking local businesses, meaning it affects our bottom line. When people search for businesses like mine in my neighborhood, and it's not just where I live, but my neighborhood is also my network. It's also my community. It's also my public relations. Wellness of Life organically comes up in the search, and people can view my profile and learn everything they need to know about my business based on convenience. And this is critical to me bringing new customers based on also establishing retention based on being more profitable. Half my business and my customers find me and decide to do business with me after the first reviewing of information based on Google profiles. So therefore, the preference also helps quick customer references, convenience, but most importantly, It creates the person to be able to have the knowledge and information that most people use based on they may not do their own research, but it gives them quick access. I cannot speak to what ban on self-preferencing would do to a giant tech companies like Google and Amazon. That is not my concern today. My concern today is about small business owners. It's the American dream. It's why most people even come here to experience that, to live that. And most small businesses may not even survive. And it's a part of contributing to what we believe in. So therefore, when you use Google as a powerhouse to help small businesses like mine, that's a good thing, and it should recognize it rather than breaking it. These platforms help us to retain more customers, combat inflation, and expand our capacity for substantial growth. Dismantling big tech will disrupt the digital services we rely on and make it even more difficult for us to succeed and achieve in the American dream. During COVID, if we were not online, we were not visible. So therefore, a brick and mortar that people could not go into, we were able to still keep our business going based on online preferences. Now, what's yet to come, we don't know. However, it sustained us. So therefore, these platforms retain more customers. And so therefore, when you consider recommending legislation, please ask yourselves a simple question. Will this policy fracture small businesses or support our bottom line? Thank you so much for your time, effort, and energy. I appreciate your servitude.
Thank you very
Oh,
much.
there we go. Right on time.
That was perfect.
Thank you.
Now, you are not our last speaker.
Okay.
There was a hand up I didn't see.
Okay, good. That means there's more.
One more person.
Awesome.
Thank you for coming.
Awesome. Thank you so much for your time. Okay.
Good afternoon, and thank you for your time. My name is Caleb Williamson, and I'm with an organization called ACT, the App Association. And I'm excited about who we are. We are a trade association that represents app developers and startups. Our charge is primarily to go around and really share the perspective of tech policy issues and debates from the perspective of the smaller businesses in the tech space. And to that end, I won't be before you long, but first we want to thank you all for the thoughtfulness in this entire 18-month and to be continued process. We have been tuning in, listening in, and I was gracious for the opportunity to come in and see Sacramento and get involved. And so to that end, I do want to talk very briefly about some of the things that many of the startups that we have worked with have shared when it comes to things such as mergers and acquisitions. And for us, for many of our members, when they're thinking about their American dream, most of it includes an exit strategy. Most of the founders that we're working with, when they're forming their business, when they're meeting with potential co-founders, they have an exit in mind. And so when we're talking about mergers and acquisitions, I would be remiss if I didn't address the importance of an exit strategy for many of the startups. Many of our founders are also serial entrepreneurs. And so to that end, what does that mean? That means that they have run the gamut. They have done the traditional, pitch competitions to win over some VC funding. They have asked for bootstrapping. They have bootstrapped. They have asked their families for loans, and they have pulled pretty much from their own personal savings. But what does a merger mean for them? What does an exit mean to them? For many of our members, an exit is an opportunity for you to recoup all of the money, blood, sweat, and tears that you have put into a small tech company. It provides an opportunity for you to start a new venture without having to go through that same round again of going to VC after VC after VC. It provides an opportunity for you to bring on fresh talent, newer talent, highly capable talent, and pay them up front instead of with potential and promises such as shares in the event that we do IPO. In the past 3 months, I've traveled to a few different states for various tech conferences, and I guess you can say over the course of the year. So when you're looking at places like San Francisco Tech Week, when you're looking at South by Southwest, when you're looking at CES, when you're looking at New York Tech Week, there are thousands upon thousands of founders and small tech company owners And every single, oh, I'm not going to say every single one, that's a sweeping statement, but many of them fill up every single panel. They fill up every panel that talks about an exit strategy. And many of them also recognize that the venture that they're building is likely not going to be their forever gig. They have other plans, other goals, and a merger and acquisition actually, for our members, helps them achieve their larger goal for what they want to accomplish. I have about a minute and a half left, but I do want to share that a point from one of our founders when we had a fly-in in DC, where we brought about 70 startup founders to DC for meetings with the White House, for meetings on the Hill. And one of our founders said that tech entrepreneurs today are not trying to build the next computer. They're not trying to build the next phone. They're trying to leverage technology to solve real world issues. And I want to leave you all with that. When we're talking about what the small businesses in the tech community are using technology for and what they're building, they're trying to build solutions to everyday problems. And technology is helping them do that. Mergers and acquisitions will also help them do that as well. Thank you.
Now, the commission, I'd like.
Once again, thank you. Thank you for that. So it's not lost. On behalf of the full commission, I'd like to thank everyone who's offered comment today, whether in person or online. The last time I checked, California was still the largest subnational economy on the planet. And if we were to finally tire of all the neighbors and we struck out on our own, we would be the 5th largest economy on the planet. And my own view is that we've reached that stage by empowering as many people to speak as possible and by stimulating rather than stifling debate. So we're looking forward to hearing from even more people as we go through this. A couple of clarifications, simply so that there is no misunderstanding on the public record. Our working groups were formed quite some time ago to help focus the commission and educate the commission, not to make any decisions. We remain free to disregard absolutely everything they've told us. They're here to get us thinking, both the commissioners and the staff. We are not considering active proposals at the time. That is premature. There is a good bit more of this bubbling and percolation that we need to do before we begin zeroing in on inflection points and proposals. And finally, I would suggest we are a policy body, not a political body. We may annoy many of you, but that's our prerogative, not being elected. We will consider all input, and then we will begin formulating proposals, leaving it to the legislature and the government, the governor, to bring politics into the analysis. Are there any final questions for our working group and panelists before we allow them to go about the rest of their day?
On the last gentleman who spoke, and maybe for our merger and acquisition working group, at dinner time, quite often my wife and I watch Shark Tank. And so the notion that a lot of the new entrepreneurs who were looking for Shark Tank money or whatever have in mind, I'm not intending to have my small business become the next Amazon or Microsoft. I'm looking for a limited solution or something that I can then merge or sell to some other big company who can buy me out. And how does that for our merger folks, how does that kind of goal or need on the part of a form of small business interact with the you need to prevent consolidation in the marketplace and all that sort of stuff. I'm as opposed to like the concern that some of the booksellers have about Amazon as our competitor, and the growth of their online book selling puts us out of business. This kind of small business seem, and the people running it see themselves as I want to develop a thing and then sell it and then I'm take the cash and get out of there. How do you put that sort of different perspective into the analysis on mergers and acquisitions?
A very good question to end our day, Commissioner. Let me respond in a couple ways.
Yeah.
One is that the M&A in the tech sector, there's a lot of such activity, hundreds of such cases, but they fall into different categories. It's quite clear that some of the app developers and software developers generally don't have a way of commercializing whatever their bright idea is, and they are clearly in the business in order to hand it off to somebody else who can do so. It's part of the obligation of the antitrust agency to separate out those cases from those that are more problematic. But the other part of it is, who do they get to sell it to and with what consequences? So if Amazon or whoever is already the dominant buyer of such, acquirer of such apps and software, as opposed to a variety of other platforms and tech companies that might do so, that raises quite a different issue. Are we necessarily in favor of all of those bright ideas increasingly being vacuumed up by the dominant tech company? So that's a separate issue, but it's one that is raised by the same kind of acquisition that you described. Again, that's part of the obligation of the agency. And as we've discussed, it's part of the issues before the commission, whether there's need for more guidance or powers for the antitrust process here in the state of California to deal with the increasing consolidation of those functionalities that app developers and software developers do come up with in the hands of the dominant tech companies. And so I would say those are precisely the questions that we've been trying to highlight, and a good question on your part.
Okay, thank you.
If I could just add a brief addendum to what John has said. I think most of the transactions that the gentleman described would not raise any anti-competitive concern. But if it's a question of Google buying up technologies that are going to be complementary to search, now we have a globally massively dominant firm in the search industry, and they're potentially taking all of the technologies that might enhance a rival. Now that's a concern. I often give sports analogies to my students, right? It's
distinguish
like,
between those.
Pardon?
How do you distinguish?
Well, because Google has a large amount of market power, which is different from another acquirer, right? So the identity of the acquirer, the technology matters a lot and can be screened by the antitrust agency. For example, the Boston Celtics just won the NBA championship. We wouldn't give them the first pick in the draft, right? We would be concerned about doing that, and it's the same idea.
Okay.
Anything else from Commissioner King?
I just want to make a brief comment. First of all, thank you for all the wonderful input. It's been a pleasure hearing so many viewpoints from the most powerful entities in the world to some of the smallest entities in the world, and talking about how these issues affect them. I just want to make a brief comment about something that was in our packet, which I found very illuminating. There was a letter from a group called Liberation in a Generation that made very moving arguments that I hadn't thought about before, about the impact of mergers and acquisitions on brown and black peoples and indigenous peoples in the United States. And I just felt that it'd be remiss for me if I didn't mention that I hope that if we focus on those issues, assuming we do, that the Asian Americans need to be considered in that context, because after all, the original monopolies in the United States were the railroads. And if you could think about the impact of monopolies on a racial group, certainly the Asian American experience would attest to that. Historically, Asian Americans have been in the laundry business, more recently in the restaurant, garment, and spa businesses. So there's other categories that are affected by these mergers and acquisitions issues. And I didn't want to make a political stance about this, but I just wanted to point out that it was interesting that the letter passionately argued for how these issues affect brown and black peoples. And there's many groups that we have to consider as we consider these ideas.
Thank you. And a final thank you again to our working groups. We know you're putting in a large amount of time to educate us, and we very much appreciate that. Thank you all. Executive Director, have we concluded our agenda for the day?
We have, and so we can entertain a motion to adjourn.
Move to adjourn.
Is there any opposition to adjournment? Hearing none. He's holding the. Motion carries. Thank you.
I hope your trip out to California